Thank you. Thank you for these excellent presentations from Carlo Tovo on the Luxembourg court and from Thomas Lampert on how the hackathon works. Unfortunately, I will not be with you in Bologna. I have to be in Pristina at the same time. But I'm glad to present today the codices database or dataset of the Council of Europe's Venice Commission. Just for those of you who have never heard about it, and there will be many, the Venice Commission is a part of the Council of Europe which gives advice on constitutional matters, including setup of institutions, human rights, on legislation prepared by the member states of the Council of Europe and the wider membership of the Venice Commission, which includes Latin American countries, North African, Central Asian countries, South Korea, and so on. Within the framework of this World Conference, the Venice Commission was developed the World Conference on Constitutional Justice, which unites 120 courts in 116 countries. It's really worldwide, wider than obviously the Council of Europe and the Venice Commission. And the idea is that the judges from these courts should, through using this database, get inspiration on similar topics. So the purpose of the hackathon is to help judges to find out about judgments in different countries, how others dealt with it, is the very purpose also of this codices database. And the idea was, of course, that we have to bring together the courts so that they can exchange usefully. And this is done through summaries of these cases called précis, which are published in English and in French in most cases. And from here, I'll turn on my screen sharing. I hope this will work. Screen. Oh, I have two screens. Can you confirm that you see this codices database?
Yes, we see.
Yes,
okay.
We see it.
So you see, this is it's a public database. Everyone can access it, and you see it has various parts. In the introduction, précis being processed means that these are summaries of cases which are not yet finally proofread, but the courts wanted to have kind of an early warning of what has just been decided in other courts. So we added this part, précis being processed. So it means that this part is not even proofread properly, but everyone and the wider public can access it. Précis, here we have some 12,000 summaries by continent, from Africa, from various countries all over. But what is most important, there's court descriptions, the constitutions of the countries, because this is about constitutional law, the laws on the courts, and various reports. But the most interesting part here for our hackathon will be the full texts, because this is what you will be able to work with. And you see this is sorted first by continent, as we are a European organization. Europe comes first, sorry. And when you click into a country, a full text, you will see, oh, this Albanian case from March 2023 is not available in English or French, but we have it in Albanian, which can be a problem to read in some cases. But this is why we always have also these précis, these summaries of the cases in English and in French. But if we go further down, we will see that we have also the European courts. We have under the heading, the country, let's say, Council of Europe, we have the European Court of Human Rights. And if we go further down to European Union, the Court of Justice, we have judgments from the Court of Justice in Luxembourg, which we just saw in the previous presentation. So it is a wide mix of many judgments from many courts. And the big difference compared to what we saw for the Luxembourg court is that they are in radically different types of presentations. We have just seen judgments from Luxembourg. But if we now look, for example, into an Irish judgment, this is a common law country, you will see that here it's a judgment of an individual judge, Justice Clark, who delivered it, and he writes at length. This is a very, very long judgment, goes over pages and pages, and it is even a personal. He says, on this basis, I did not consider it appropriate. So you see that the style of common law judgments is very different from what we have seen from the Court of Justice of the European Union, which is inspired by French judgment drafting, and this is also where they deliberate in French in total secrecy. And we have just heard that all judgments exist in one of the languages for that court, plus in French, because this is in the language in which they write the judgments. But if we go to a different country, for example, where we have an English judgment, this is Macedonia, North Macedonia, a judgment from February of this year, decision on Article 112 of the Constitution and so on. Here we have the decision, and this is obviously a judgment which was translated. This was adopted in the Macedonian language, but we have it also, happily enough, the court translated its own judgment, and we have the included in the codices database this judgment. And again, it's a completely different style, acting upon an initiative. You see argumentation. You have at the very top here, you have the decision. Article 1, paragraph 1 on the part ethnicity are hereby repealed. So this was a judgment of a constitutional court where this there was a challenge against a law. The constitutionality of this Article 11 was challenged, and certain parts of this this article were repealed. That means they're no longer part of the law. This is typically what constitutional court do. I should mention that the codices database is kind of a mix, and we saw this already, of as concerns the courts, because wherever in a country where there is a specialized constitutional court, like in North Macedonia, like in Germany, like in France, where there is a constitutional council, this is what goes in here. But for Ireland, there is the highest, the only constitutional court is the Supreme Court, which also acts on constitutional basis. It will also repeal or declare unapplicable provisions of the law, but this is done in the Supreme Court. So you will find a mix of courts within this. We still have Russia, even so Russia was expelled from the Council of Europe. We still have, of course, previous judgments here, but you see that in Asia we have Bahrain, Cambodia, Japan, in Africa, many countries, Mali, Mauritania. Mali is now a bit more difficult. So you see, these 12,000 judgments which we have there is a mix from a lot of and very diverse systems. And as a consequence, the full texts which we have in this full text part do not follow in any way a coherent structure. This is why we have in the codices database these summaries. And if we go again to now for Albania, where we have summaries, they always have a coherent structure. We have the country name, the name of the court with a link to its description. This was taken by the plenary of a court, not a chamber, the date, and so on, where it was published. Then we have two types of indexing: keywords of the systematic thesaurus. This is a 5-chapter keyword system which breaks down. You see, you have the chapters 3, 4, and 5, fundamental rights. So it describes the constitutional aspects, but then you also have the alphabetical index where it says magistrate, right to profession, magistrate, criminal offense, bar to appointment. You see, have a link of some factual elements. Then you have the head notes, which are the points of law, really the outcome of this judgment from the Albanian constitutional courts, and because as the database is so big, you will get hundreds of replies. And so if you're a lawyer and you do research there, you want to find the cases which may be relevant for you. So the most important thing is to read these headnotes, and then you see what the court really decided on as a point of law. And you have summary, which is the first part, Roman 1 here gives a short summary of the facts and what happened before, to which other instances this case went, possibly before it came up to the court. And then in part 2, you see what the Constitutional Court, in this case of Albania, decided. However, what you will see mostly will be these full texts. We already saw them. So you may get a mix of cases we already saw that there will be the ECJ dataset, which is of course separate. We have this as well, but you will have very long and very elaborate cases from common law countries. There could be cases from very much shorter ones, like the one from North Macedonia, and they are obviously quite incoherent as concerns their structure, because every court has their own system. For within their own, if you compare North Macedonian cases to other North Macedonian cases, you will find, of course, that there is a coherent structure between their cases. But as you will be working on cases from different courts, you have far less structural and formatting elements, formal elements to look into. So this is what you can expect from this codices data set, which is a bit maybe harder to approach than the much more coherent data set from Luxembourg, which Carlo Tovo just presented to you. So I hope that your systems will be open enough to find coherences on facts, because I suppose this is what you will go into, which link even so coherent, such coherent cases between them. But this is, of course, for you to play around and to deal with. I think this is all I wanted to cover. And just as a final word, I was quite impressed also by the Hackathon number 1. And if you do as well as the first version, I think we look forward to really good results. And I wish you much success. I'm, of course, available for questions as well. Thank you.